Hi once again. This is a beginner's guide to understanding law, and it's based on a new book that I bought for $4 at a book sale. This is a textbook that all lawyers attending university learn in their first year, and it's called Understanding Commercial Law. So hopefully this may explain things in a more simple fashion, what we're trying to, or what we're setting out to achieve. So let's have a look at this. In this textbook, Understanding Commercial Law, the first chapter asks what is law, and then they go into the explanation of it. There are various definitions and descriptions of law in general, and laws, examples of the law in particular. The law may be described as a collection of enforceable rules applicable to the behavior of the citizens and institutions of an organized community, such as a nation. Laws may be described as the large number of rules imposed upon and enforced among persons in a society for achieving of peace and the resolution of disputes. The sum total of these laws is called the law. Now, just looking back a little bit here, we see a word there, collection. Collection. In the absence of agreement to the contrary, it is the buyer's job to collect the goods, not the seller's job to send them. So when we look at that in the broader sense, and what I've done through all my videos is to try and teach you not to take any word at face value. Look the meaning up. Now, what that section there is saying, the law may be described as a collection of enforceable rules. And collection, saying it is not their job to tell us. It's our job to find out what the rules are. Many other definitions and descriptions can be found, but in general, legal commentators agree that the concept and existence of law is a characteristic of all human communities, past and present. This has been going on for thousands of years, folks. We have now luckily reached the age of enlightenment, and we're finding out all the things. Look, I couldn't have found out the things I'm finding out now 5 years ago. The internet is bringing everything out, and hopefully this will raise your awareness to a higher level. The laws of a sovereign nation state, such as New Zealand, share the following factors. This doesn't only apply to New Zealand, it applies to all English-type countries. 1. They are made by human beings and are intended to regulate the behavior of legal persons. These terms are not synonymous. See Chapter 4. Now we'll come to that in a second. They are often expressed in language, direct or indirect, of command or prohibition. Example, every person commits an offence against this Act who, in or within the view of any public place, uses, displays, destroys, or damages the New Zealand flag in any manner with the intention of dishonouring it. And this comes from the Flags, Emblems and Names Protection Act 1981. Okay, so what they're telling you is if you are a legal person, you can be sued or whatever under their acts, such as Flags, Emblems and Names Protection Act. Now let's look a bit further at legal persons, because this is what you need to know. And this is what the first year law students get. So if you understand this, then you'll get the whole crux of the matter very, very easily. Business organizations consist of human beings, but there are a number of legal forms and structures under which they operate. Notably, the law has adopted the device of an artificial or fictitious personality for certain forms, where the organization has a legal life of its own. separate from the natural human legal persons who are involved in it. Okay, do you get that? The legal persons, or the name that we use, is a separate person to what we are. It's not a human being. And it goes on a bit further. A legal person is an entity, a distinct being, recognized by the law, able to exercise rights and subject to corresponding duties within the rules of a particular legal system. Such a person, therefore, has a legal personality. Now, that is how they get us into their system, is that we believe that the name that Mum and Dad gave us is our name. But it's not. It's a legal person. And they're telling us there that this is an entity which has a fictitious personality for certain forms. Okay, so let's move along now and find out the validity and enforceability of the laws are derived from the authority of the sovereign ruler. Now, in New Zealand, it is a combination of the monarch and the parliament. Such authority enables the laws to be created, modified, or abolished at any time as a result of due process, the following of agreed valid lawmaking procedures. So they've set up a system such as, it's called Parliament here, and they sit down and they follow a certain rule where they put a bill into Parliament and they read it 3 times, and that is their valid lawmaking procedure. And if it passes, because they have a majority in Parliament, or they all agree to it, then the law is created or modified. The laws may be applied formally in courts of law and presided over by judges who are salaried by the state. The judges sometimes, with the help of juries, attempt to ascertain whether the laws have been infringed or complied with, and they make decisions accordingly. Such decisions are called judgments, and they are ultimately enforceable by the authority of the state, if necessary by physical coercion. Take note of that. To permit successful defiance of court orders would bring the law into contempt. It certainly would. The orders often involve the imposition of sanctions such as imprisonment or an order to make compensation upon parties to trials, actions, or appeals. Now, what they're saying here, they make up these laws and then they get you to abide by them by physical coercion or threat or any number of things that they use. And so, as long as we're aware of them, we can take steps to our advantage. Law and laws also have alternative usages, and so now we'll explore them. These terms are sometimes used in connection with other aspects of human society and behavior. Examples are so-called laws of religion, science, associations, and morality. The difference between such laws and law, as already found, are instructive. So let's look at religious laws. These rules said to be derived from some deity. Now, there are many deities, and mostly in the West we observe Christianity, but there are Jewish deities, there are Muslims, there are Muhammad, Buddha, all the different deities which are confined to the followers of the particular religion. They often include internal sanctions for those who transgress. Where they conflict with the state laws, then state laws prevail. The laws of some religions, however, often overlap with ordinary secular law and have historically been the origin of some of them. A comparison of the 10 Commandments with modern New Zealand law is a recommended exercise. Now, when you understand that the Bible is the key to their system, or the system that we are under, you will see that if you look at the Bible, you will find a corresponding statute to what is in the Bible. Then you will see that the Bible is the law book. They just make statute to enforce the fictitious entities that we operate under. So why are laws obeyed? The majority of the members of an organized community which is not in a state of civil war obey laws because they generally approve of them and or they fear the consequences of non-compliance with them. Now, those two things alone, they threaten you, so you fear the consequences. So whenever you get a threat, I'm going to lock you up, I'm going to throw you in jail, then it is fear or approval that makes these laws obeyed. Okay, so now we're going to delve a little bit deeper. This book is great, by the way. It's made everything so clear. For the sake of convenience and specialization, law has traditionally been divided into distinct sections or departments, each with its own characteristics. The most important division is that between the criminal law, for which a breach involves punishment of the offender by the state, and the civil law, which involves the relationship of individuals. Now, I want you to take note of this civil law because this intertwines with what we're going to be coming to. A broader classification involves the distinction between public law and private law. Now, that's what we want to know. Public law is concerned with matters that affect the state as a community, while private law is concerned with matters that affect the rights and duties of individuals among themselves. Now that's what we're after, the private law. Individuals among themselves, and we want to be individuals. Okay, so when we go further into it, we'll find that the public law is international, administrative, constitutional, and criminal. Now I want you to look at two in particular, administrative and criminal, because those are the two laws that concern us the most. Okay, so New Zealand law today, when we come to private law, we come to contract, tort, trusts, family, and property. Now, the private law, as it said earlier in the public law there, is individuals amongst themselves. So when we're dealing as individuals, we deal by contract. Get that very clear. We deal by contract when we're in the private. Civil and criminal law. Civil law is made up of all the different areas of private law. This is really defining it now. Civil law is made up of all the different areas of private law. This type of law, A, is concerned with laws which govern the relationships between individuals as distinct from individuals and the state. Now, the public law is the state versus the private. Civil is between individuals or private. So the state can't intervene. And B, it excludes laws which define and control criminal behavior. So those laws are in the public. Has been developed by common law and equity. Now this is where a lot of people know about common law and a lot of people know about equity. People know that common law is private between individuals, and equity is how we get our remedy. So what they're telling us here is that the civil law is a combination of civil, common, and equity. And it's also found in statutes. Examples include the law of contract, the law of tort, and property law. Hope you're starting to get a picture here. civil court proceedings, if a citizen feels that he or she has a claim as a result of a breach of the civil law, the common law, then he or she may take the matter to court. Here are a few examples of how this happens. If you have someone who has wronged you and you need to recover a debt, an action for a breach of contract, as I told you earlier, private law is all about contract. A damages claim for negligence or recovery of goods or land. Now, this is all done under civil law. And as we said earlier, civil law includes common law and equity. They're not separate. The function of a civil proceeding is to determine and declare the rights of the parties and, where appropriate, provide a remedy or compensation. In a civil proceeding, the individual legal person sues another individual or legal person. Now, just want you to dwell on that because we'll come to this in a minute or two. The person who brings the action is known as the plaintiff, or in a disputes tribunal case, they're called the applicant. The person against whom the action is brought is known as the defendant, and once again, disputes tribunal, it's the respondent. The defendant either admits liability or defends the claim. The burden of proof is on the plaintiff. So when we're in the private, the burden of proof is on us to make sure that any claim that we make, we have the proof for it. This means that if the plaintiff's responsibility to prove his or her claim, it is only after the plaintiff has done this that the defendant must try to show an absence of liability. If the plaintiff cannot discharge the burden of proof, then the claim will be lost. You wouldn't want to do that, would you? Now, here's the big difference. The standard of proof is on the balance of probabilities. This refers to the amount or degree of proof or evidence that the plaintiff must produce to be successful. The balance of probabilities refers to the requirement that when the court weighs up the evidence of both parties, the scales must tip in the plaintiff's favour if the plaintiff is to succeed. Now, most of you will be aware that when you're in the public and you get dragged into a criminal case, it's beyond reasonable doubt. But when we're in the private or in the civil, because we have to be very civil with our brothers and sisters, don't we? It's on the balance of probabilities. It's a lot better, isn't it? The result or outcome of the action will be judgment for the plaintiff or judgment for the defendant. If we have put everything together in the right manner, it will be for the plaintiff. Plaintiff always wins. And the court may grant a remedy. Let's take a brief look at why we are in the situation that we're in. Because we are legally dead, now we covered this very early in this presentation, our estate is being administered by our public trustees. Okay, now we have to understand that it is the trustee's duty while administering the estate to ensure that the estate makes a profit. So the administrators of our estate, or that's the name that we've been operating under, and keep going back to the born identity. When we keep operating under that, we're an estate and they have to administer our estate, and so they have to make sure that we get a profit. Whenever we operate in the public, we are admitting to being the legal fiction, and that's where we keep going wrong. So under administration, you need to understand what administration is all about. The rule of law states that a person who acts as a corporation is treated as a corporation. Now you saw right at the beginning there that legal personality, that is a corporation. And the more we keep using that name or that corporation, we adopt that status. So the moment we stop using it and go into the private or the civil, we start to find a different outcome. Now that we know the difference between public and private, we will need a little understanding of contract, because we've already covered that, so that we can avoid unwittingly going back into the public. The 8 parts of a lawful contract. Now the first part, parties competent to contract. The parties to a contract should be competent, being of age of majority or consent, of sound mind, and not disqualified from contracting by any law to which she or he is subject. A flaw in capacity may be due to minority, i.e. underage, lunacy, idiocy, drunkenness, or status. Now here's the part. The status of the parties should be of like kind, being artificial legal person and artificial legal person, or living man woman and living man woman, allowing 2 or more parties but never a mixture of these kinds. So you can't have an artificial legal person and a living man and woman, and this is where we have gone wrong every single time. We must go in as the 2 parts. So understanding what we're doing now should help you with your paperwork when we go into these courts, to make sure that we don't mix the 2, because a contract is only valid if it's between 2 like-minded parties. Two, this is the second part of the 8 parts of a binding contract. Free and genuine consent. The consent of the parties to the agreement must be free and genuine. The consent of the parties should not be obtained by misrepresentation, fraud, undue influence, coercion, or mistake. If the consent is obtained by any of these means, then the contract is not valid or lawfully enforceable. And I'm sure looking back, you'll find that many agreements that you have gone into have been forced upon you, or were never ever given full disclosure, which we now come to. When negotiating contract, full disclosure is the act of providing all material information or telling the whole truth about any matter which may influence the decision-making of the other party or parties before they decide to enter into a contract. Now, I can guarantee that any contracts that you have done with the state, you have never been given number 2 or number 3 of the 8 parts of a contract. Number 4, sufficient consideration. The consideration is something of value. In our case, all they need is the signature. The consideration is something of value possessed by the parties that is brought to the contract table. And this something of value is bargained for and given in exchange for a promise or a performance. All they need is our signature for a promise or a performance. The parties must each receive a benefit and each suffer a detriment. To be enforceable, a contract must have sufficient consideration. A contract is unenforceable if it has insufficient or unequal consideration without agreement. Number 5, it must have certainty of terms. The terms and conditions of the contract must be fully disclosed and agreed upon, and must be certain and fixed, i.e. not variable as with interest rates. How many contracts that you or I have signed that they have given us certainty of terms? Guarantee they haven't. Meeting of the minds. A meeting of the minds consensus and item occurs between the parties when they recognize each other, understand their mutual obligations, and agree. This meeting of minds can only occur between like minds and status, man-woman with man-woman, or when these are acting as legal person with legal person, telling you there, like minds. If we're acting as legal person with legal person, you have to understand the difference here. The meeting of the minds can only occur between the living, but when we hop up and act as the legal person, then we become the legal person. A corporation and another corporation may enter into contract by way of accommodation parties. Listen very carefully to this. And a sentient being and another sentient being may enter into contract directly, but a corporation and a sentient being together cannot enter into a contract as they are not of equal status. So if you're going to go in as the corporation, you must go in as an accommodation party. So what you put is by accommodation. Signatures or autographs. Written contracts between artificial legal persons must carry the wet ink signatures of the parties. Can an artificial legal person put a wet ink signature? Absolutely not. But because a wet ink signature is an accommodation from a living man, declared or not. Now, if you don't declare it, then you are that artificial person. If you declare it, say by accommodation, then they know that there is a living person behind it. So be very careful with this. Written contracts between sentient beings must carry the wet ink autographs of the parties and or living identification, such as a thumbprint. Now we're talking. Living status is recognized by thumbprint, or more often by an unambiguous declaration with the autograph, such as authorized agent, written below. Now you can have authorized agent, you can have by accommodation, or you can have your thumbprint. That is the only way that you can absolutely go into contract. So whenever they come at you in any legal capacity, remember number 7 of contract. Privity of contract. A contract exists only between the parties. No third party can obtain rights contained within a contract or buy or sell a contract without the express permission of the original parties. Okay, they're telling you privacy of a contract. It's only between the parties. And in summary, the public is an entity called a legal fiction. The private is the living man or woman. This is very, very important. Public is run by administrators. Because the public is only in a state, administrators must run our state on our behalf. And we keep falling for it, thinking that that is us when it is not. Civil is private relations between men who contract or sue. Get that very, very clear. And if you act as a corporation, you will be treated as a corporation, so you will pay the price. Now, hopefully, this has cleared up the misunderstandings that most people have about the name and the relationship between us and the state or the government, as it's so called. And this is a textbook that I picked up for $4 at a book sale called Understanding Commercial Law. It's amazing when you go looking for the truth what you find. So good luck out there.